Hello, my name is Phil Grafton and I'm the Monitoring Officer for Stratford-on-Avon District Council. For short, I'll refer to the Council as SDC. We are here to talk about the Code of Conduct adopted by SDC for its own councillors, and we will also be covering the Model Code that SDC is promoting for adoption by town and parish councils within the district. Whilst these two codes differ slightly, they are in essence very similar, and I will point out the differences as we go along. To help me with this training session, we have two special guests who are an integral part of the ethical standards arrangements for all councillors in the district.
Hi, my name is Sarah Goodall and I am one of the two independent persons who assist the Monitoring Officer in dealing with Code of Conduct complaints.
Hello. My name is Rosalind Bolton and I am one of the two parish representatives who sit on the SDC Audit and Standards Committee, which oversees standards of conduct and conduct training across the district.
The aim of this video is to help councillors understand and put into practice the requirements of their code on a day-to-day basis, as your code lies at the heart of everything you do as a councillor. This applies whether you are an elected or co-opted member. The SDC website provides all the documents you need, including both codes of conduct with general guidance and other documents linked to the code. Every effort has been made to ensure that these documents are accessible and that they are straightforward and easy to read.
This video is split into three parts. Firstly, we deal with the conduct rules, and you will be invited to look at some case studies that draw out the principles. In the second part, we take a look at personal interests, and lastly, we will take a brief look at the complaints system. At the end of the video, we have included some contact details for people who can provide help and advice on your code. This video is designed to be watched by a group of councillors, together with an officer who has some experience of standards issues. In this way, you are likely to get much more insight from the training. It's also a good idea to have a copy of your council's code and the case studies with you before you start. If you are a town or parish councillor, your clerk is the ideal officer to be present, as he or she is also your first port of call for advice on your code. They will ask you to sign an attendance sheet at the end of the session, and this is important because it provides evidence that you have received the training.
If you are a new councillor, the thought of having to follow a code of conduct might feel strange at first, but the fact is that the Localism Act 2011 requires each and every relevant local authority in England to have a code of conduct to regulate the conduct of its councillors, and this includes county councils, district councils and town and parish councils. In fact, the legal requirement to have a code of conduct goes back much further than 2011. Parliament has long taken the view that the public has a right to expect that their representatives act in a way that ensures that there is a set of standards to regulate behaviour and that their personal interests do not play any part when making decisions on behalf of the public. The way you conduct yourself as a councillor is very important in upholding your own reputation and maintaining the confidence that the public have in councillors and officers at all levels of local government. The Localism Act requires each county, district, town and parish council to adopt its own code based on the Nolan principles, more of that later, and to include provisions for declaring certain personal financial interests and possibly other personal interests. Your town or parish council has chosen to adopt the SDC Model Code.
The Act requires district councils, in this case SDC's Monitoring Officer, to deal with all complaints of breach of conduct for all district, town and parish councillors within the district, regardless of the code that has been adopted. As part of the complaints process, district councils are required to appoint at least one independent person, we have two at SDC, to give an impartial view in individual complaints to the monitoring officer. The code adopted by SDC is slightly different from the model that we promote for town and parishes in the district, and that's because of the differences in size, function and resources. But rest assured that the purpose of your code is to provide a clear, unambiguous framework in which to conduct your public life, while keeping bureaucracy to a minimum. Let's now take a closer look at the two codes. These principles of public life were introduced by Lord Nolan, who was the first chair of the Parliamentary Committee on Standards and Public Life, and the principles have since become referred to as the Nolan Principles. They are widely embedded across public life and form the basis for our two codes of conduct. The leadership principle asks you to demonstrate these principles in your own behaviour and requires you to challenge others whenever poor behaviour occurs. Do take time to reflect on each of the principles.
The code only operates when you are acting in your role as a counsellor, so it does not apply to your private life. That said, please remember that in your public office, your behaviour is, in practice, always potentially under the spotlight, and the reputation of your colleagues and your council depends on your good conduct at all times. The behaviour rules under Part A of the Code are largely self-explanatory, but it's worthwhile going through them briefly one by one. Number 1, the principle of respect for other people. Disrespect runs from the mildly offensive right up to criminal conduct such as harassment. An increasing amount of the complaints I receive are related to the use of social media. So for further information, please see the linked document on social media. Also, SDC counsellors need to read our protocol on member-officer relationships, which explains the role of members and officers, the need for mutual respect, and the proper channels for resolving conflicts, that is, outside of the public domain. This document does not apply to town and parish councils. 2. Use of the counsellor position for personal financial gain. As we will see in part 2 of the video, failure to declare or take action to avoid involvement in council business that affects your own financial interests can constitute a criminal offence. This one is serious. 3. Using your counsellor position to improperly confer an advantage on yourself, your family or friends, or conferring a disadvantage on someone else is another big topic and goes back to the Nolan principles of selflessness as opposed to selfishness. Why did you want to become a counsellor? 4. If you ever find yourself under pressure from a person or organisation that offers you some financial benefit to make a decision in their favour or offers you a reward for acting in a certain way, please contact me immediately. Bribery is a very serious criminal offence. 5. Whatever the size of your council, it will have some resources such as land, property, staff who work for your council, printers, paper, etc. All of these resources are funded by taxpayers. They are not there for your personal use. They are not there for your use in your political role, except in some very limited circumstances. For more information, for SDC councillors, please see the resources policy. Again, this document does not apply to town or parish councils. 6. Generally, all council business must be conducted openly and transparently. This includes public access to council meetings and the agenda, reports and minutes of meetings. However, by exception, information can be withheld from public access and in those instances where you have a general duty not to disclose confidential information. On the other hand, you must not prevent access to information where a person has a legitimate right of access to the information, for example, under freedom of information legislation. 7. The last behaviour rule and the one that covers all of the other 6 rules, is to remember that your conduct as a councillor will have an effect on the way that the public see you, your fellow councillors, and the council that you represent. Trust and reputation takes years to establish, but it can be all lost in an instant. Planning applications are a danger zone for councillors, especially if you're a district councillor on our planning committee. To help you, please see the linked document, Good Practice Guide to Planning.
That brings us to the end of part 1 of the video. In part 2, we'll be looking at personal interests, how to spot them, how to declare them, and the effect of personal interest on your councillor role in terms of participating in council business and making decisions. It's now time for you to pause the video to allow you to take a look at the case studies on the behaviour rules that your clerk will circulate, so you can discuss these with your colleagues. At the end of your discussion, your clerk will circulate the model answers. Once you've finished the exercises, we'll move to part 2, personal interests.
On becoming a councillor, you must declare particular matters in a public register. This helps to give the public confidence that your work is conducted transparently and with integrity in areas such as planning applications, for example. There are 3 types of personal interest. The first 2, which you must declare on the public register. Disclosable pecuniary interests, or DPIs for short, is a narrow band of financial interests, any one of which could be directly affected by an item of council business. An example would be you submit a planning application for your own house. It would be plainly wrong to participate in any decision to be made on that application. Failure to declare a DPI or to give false or misleading information is a criminal offence. There's a form to complete with some notes, and your clerk will supply you with a copy. Appendix A of the code sets out the list of categories of interests that you must declare, such as employment, sponsorship, and ownership of land and property. Common errors I see in completed forms are failure to give sufficient employment details, that's box 1, and failure to give details of legal interest in land and property, box 4. So please pay attention to the notes on this.
In the same form, you must also declare any appointments to outside bodies in certain situations, and any gifts or hospitality received where the estimated value is £30 or more. See Appendix B. These last 2 interests are known as Other Registerable Interests, or ORIs. There's separate guidance on gifts and hospitality if you need to see it. The form must be completed and sent to the monitoring officer within 28 days of your election or appointment to office. Failure to do so is a criminal offence. You must also give details for your spouse or civil partner or equivalent, although these details are shown as only your interests on the public register. It's equally important to keep your register of interests up to date. This is not just a protocol or good practice, it is a legal requirement. Again, you must notify the monitoring officer within 28 days of any change. If you have any questions when filling in the form, please seek further advice from your clerk or from the monitoring officer. Circumstances can change, and what might have been irrelevant to declare upon your appointment may become relevant over time. With DPIs, the law is very clear. If you attend a council meeting and an item of business to be discussed directly affects one or more of your declared DPIs, then you must not participate, which means that you must not speak or vote at the meeting, nor attempt to influence the outcome. If your council's rules require it, for example at SDC, then you must also leave the meeting room while the item is discussed. A dispensation allowing you to speak and/or vote is potentially available if requested prior to the meeting, but only if it meets the strict legal grounds. For district councillors, the request for a dispensation is made to the monitoring officer. For town and parish councillors, the decision lies with your council, although it could be delegated to your clerk. For other registerable interests, you must not vote on the matter. You are allowed to speak on the matter, but only where the public are also allowed to address the meeting. For example, you may want to put forward the organisation's case as to why it has applied for funding, but representatives from competing organisations would also need to be able to make their case.
A non-registerable interest needs to be declared where the matter under discussion relates to or affects, rather than directly affects, an interest of you, a friend, relative, or close associate, or affects your interest that you have declared in Appendix A, or that of a registerable body that you have declared in relation to Appendix B of the Register. An obvious example would be if your daughter owned a company that was bidding for a contract with your council to undertake grass cutting. Although this would not directly affect you, and it is not therefore a DPI, it would clearly not be right for you to participate in or influence the council's decision. So you would need to declare a non-registerable interest. Occasionally, an item of business might arise in your role as a councillor where you have a personal interest, but it does not fall within Appendix A or B of the Code. But you know that if you participated in the decision, your personal interest would prevent you from making a decision in the public interest because of bias. An example might be that your daughter has made a planning application on land that she owns. You would have an obvious bias. There's a two-step test to help you decide whether you can participate in a matter. Step 1. Does the matter affect the interest more than it affects the majority of people in the ward or parish? If the answer is yes, you then ask, would a reasonable member of the public, knowing all the facts, believe that it would affect your view of the wider public interest?
Situations can arise where a declaration of interest is not required under the Code, but you still need to make sure that you are not biased and that you don't have a fixed position on a decision to be made and retain a closed mind, known as a predetermination, right up to the point when you make a decision. Otherwise, the decision is at risk of being challenged, possibly in the courts. In general, the rule against bias looks to the appearance or risk of bias rather than bias in fact, in order to ensure that justice should not only be done, but should be seen to be done. Obviously, where bias or predetermination arises, you should not participate in the decision. An example of bias would occur if you were involved in recruiting a new employee to your council and you held a personal grudge against one of the applicants for some reason. Then clearly you should not be helping to make the appointment decision. Planning applications also provide fertile ground for predetermination. So if you have very strong views about an application and you know that whatever happens, your view will not change when you have to make a decision, and this includes giving views to the local planning authority, then that is predetermination. The Localism Act 2011 makes clear that you are not taken to be predetermined when you make a decision just because you have previously done anything that directly or indirectly indicated what view you may take in relation to a matter, and that matter was relevant to the decision. In other words, expressing a preliminary view is simply a predisposition. So, you are entitled to have a predisposition one way or another, as long as you have not predetermined the outcome. You are able to express an opinion, providing that you come to the relevant meeting with an open mind able to take account of all the evidence and make your decision on the day.
It's now time once again to pause the video to enable you and your colleagues to take a look at some case studies on personal interests with one of your officers. For town and parish councils, this is likely to be your clerk. At the end of your discussion, the model answers will be circulated.
I'm pleased to say that the number of complaints across the Stratford district, while nothing to be complacent about, are not very frequent. Across the district, town and parish councils, they currently number around 90 complaints over the past 6 years. So what happens when a complaint is made? First of all, there are helpful explanatory notes on the SDC website for anyone considering making a complaint, and about the process that will entail if they do. If a complaint is made, then before anything else, it is recorded and considered carefully by me as the monitoring officer, in consultation with the 2 appointed independent persons, to decide whether a formal investigation is required.
Your code of conduct is at the heart of everything you do as a counsellor, whether you are talking to constituents, dealing with fellow councillors, attending council meetings, making decisions, or spending money on behalf of your community. We have issued a handy 2-page summary of the code requirements that your clerk or the DS team will provide to you. If you're a town or parish councillor, your clerk is always the first port of call for advice and guidance. In addition, the monitoring officer is here to help, but we will want to know whether you have contacted the clerk first, and if you have, then you may need to speak with the clerk before confirming any advice. The monitoring officer's details are as follows: Phil Grafton, telephone number 01789 260 400, or email address phil.grafton@stratford-dc.gov.uk.
We hope you have found this video useful and are looking forward to your time as a counsellor. If you do have any questions, please speak to your clerk, or indeed don't hesitate to get in touch with me personally. Thank you for your time.